1171 of 2023. Daudi Mwangi, Daniel Nugwe, Simon Mudrai, John Kuria, Jason Majau, Samuel Kangede, Julius Blum, Peter Njenga, John Maina, Philip Kadiri, Peter Njoroge, and Joy Mulu.
Number 9, that judge, Maina Njenga. I don't know whether to give you representation first.
Yes.
Okay, I appear for Maina Njenga alongside Mr. Mburu, Simon Mburu, Mr. Cheche, Simon Mburu, who is beside me here. Mr. Cheche, he's at the back there, and Mr. Munji. Mr. Munje. Yeah, I hope I'm pronouncing properly. Yeah. He's right behind me.
This is for the 9th accused.
Sorry?
For the 9th accused.
9 accused, yes, who has not taken plea in the case.
Thank you.
Yes, Your Honor, the matter was coming up for motion.
Your name and
Miss Maina from the state.
yes.
Miss Maina. We do have a with the resident Mr. Omwenga.
Mr. Omwenga. Yes.
With the resident prosecutor.
Yes.
For 8 days. Your Honor, we do have a fresh charge sheet that have been registered in respect to the accused person. Your Honor, maybe if you're kind with that, maybe you can confirm whether we have a charge sheet.
Yes, I
Because the one
delivered.
that is in the court is in respect to E1171.
Yes.
2023. And the new one has been registered. We tell them we have the new registered.
What happens to this one? I actually am aware that two files.
Okay.
Yes, and I deliberately asked that this one be ordered.
To be availed.
So what happens to this one?
Your Honor, we wish to have E1171-23 to be retained to have a mention on 20th of June and stated so that you can be able to proceed with the case. Then we will make the necessary applications then.
I think, Your Honor, technically there is something wrong with that because there are already existing charges, and unless they are withdrawn, even though he has not taken plea, he has been charged, and it's before you. So unless those charges are first withdrawn, it would not be right for the accused to plead in a different file, because then you'll be facing a multiplicity of charges. So it's up to the prosecution to decide what to do, whether to first withdraw the existing charges, and I think this is something they know. You can't have several files in respect of the same person. I don't want to say much more at this stage, but we want to object to taking plea when there is a multiplicity of charges into different files. colleague, Mr. Njiro, would like to add something to that.
May it please you, Your Honor. My name is Dewa Njiro.
Just a minute.
I join issues with what has been submitted by my learned friend, Senior Counsel, Martha. And I'm pleased to say, Your Honor, that you will certainly be able to see the mischief behind this process that is being initiated by the DPP with the aid of the DCI. Your Honor, while I am not at the point of dealing with the substantive of the charge, the process of the charge itself is questionable. You know, this charge that is before you in E1171 was read out to the accused persons on the 19th of May. The same proceeded in the absence of the 9th accused person. Previously, Your Honor, the 9 accused person had procured an anticipatory bail in Nairobi in miscellaneous application number E165/2023.
You say, like, I
Miscellaneous application number 1 is 165 of 2023. And I'm pointing it out, Your Honor, for you to see the mischief. In that application, Your Honor, which is coming up for a mention on the 6th of June before the Honorable Judge, there was a condition of that bill term to the effect that upon a decision to charge being made by the relevant organ, the bill was to lapse. With that knowledge, Your Honor, and with the intention to perpetrate the mischief that we are addressing, the DPP, even having been served and or having knowledge of that order, decided to charge the accused person on the 19th. And the consequence therefore was that the orders lapsed. You know, upon lapse of those orders, the DCI on the 24th of May circulated a communique. 24th of May, the DCI circulated a communique on their social media page that the accused person, the 9 accused person, is at large. And they called to the members of the public that any person who knows of his whereabouts does report. Remember, at all this time, Your Honor, the accused is not aware that a charge has been preferred against him. Yet a communique of a person who has gone large has been sent out. So, having learned of that, Your Honor, we voluntarily appeared before court number 3 on the same date of 24th to have the accused person take plea under file number E1171. We pleaded with the court, the records bears as witness, and the court declined. The court abdicated on that duty. Subsequent to that, Your Honor, that judicial abdication, we were ordered to appear before the DCI on the 25th. We did appear. I do not want to recount on the drama that ensued therein. we'll do that later. But suffice to note that on that date, we informed the DCI that there is a charge that is pending before this court, and that the charge has a date of the 20th of May when the accused person was to appear and take plea. Look at the mischief. To date, when the live file 1171 has been called out, all other co-accused persons are not before you. And what does the DPP do? He decides to bring a new charge. A replication of the charges that are before you. What that technically means, Your Honor, that one, that the accused person together with his co-accused are facing fresh charges. Number two, that these fresh charges are arising from the same transaction. Number three, that there will be another separate file. There could be an argument that a consolidation will be done in the later date, but that should not be a prima facie presumption, because consolidation is not obvious. And that is the malice we are pointing out. And that is the abuse of the court process we are pointing out. And objecting to the taking of the plea until the DPP does put his house in order. And the objection, Your Honor, is that it is going to fly over the face of Article 50, infringe that right, infringe the right under Article 48, access to justice, infringe over a client's rights under Article 27, equal treatment and equal protection before the law under the principle of non-discrimination. Whereas, Your Honor, you must know that Article 25 caps and protects the rights under Article 50. It's a non-derogable right, the right to a fair trial. The question, therefore, is, it protects the rights under Article 50 by creating a caveat that that is a non-derogable right. So the question of your determination is, if he was to take plea as proposed, would that amount to the infringement of that right? If the accused person was to take plea as proposed in a separate file, bearing the same transactions, the same offenses, the same particulars, would that amount to the infringement of his right? And Article 50. Number two, would that amount to a double jeopardy? Most of that.
Yes.
Your Honor, we do confirm that the accused person here on 23 last week for purposes of taking plea. Though there were no warrants or summons to appear, and the courts declined to deal with the matter. Your Honor, the information we have is he was prepared today to take plea. And he's before this court to take plea. Your Honor, the matter that is supposed to be, that is fresh, there are charges that are not on E1123 that are included in the charge sheet. Counsel has raised issue of double jeopardy. Your Honor, we do submit that at this level, the same does not apply, as the suspect of the accused person has not been tried. Your Honor, we do at this court, the accused person supersede and take plea. It is our prayer.
short reply to the prosecution.
Yes.
I invite you to look at the charge sheet, the fresh one, and the one that already exists before the court. They are actually identical. The only difference is that charges that were previously preferred on accused number, what number is it? Accused number 1 have now been imported to our client. There is no other difference, which appears to me to be an afterthought. So the charges are identical, and the only way open to the prosecution, you want to charge him in a different file, withdraw the case against him in 117. You want to charge him in 117, then withdraw the new charges and we proceed. We can't have two multiplicity of cases on the same facts.
Just allow me to post this to the prosecution. What is the fate of the file monthly respecting the Njenga case?
I believe the directions or when the plea was taken, I believe on 19th of May.
Yes, and there's an accused person who was not created to get
To
charges.
the charges.
Yes.
You have the crime commission and because the confirm and give for consultation. But the same was supposed to come on 20th of June for purposes of pretrial.
Respecting the first 8 accused and the 10th endeavor to close that case, right?
Yes.
There is the 9th accused who is not taken plea and is charged with that charge sheet. Yes?
Yes, correct.
No, these are very simple things that we don't really have independent case on. Right?
Yes, sir.
And you asked me to have this matter mentioned on 20th. When the person who was not present in court is not present and has not pleaded to those charges.
Yeah, maybe we can take a shot at before we would request that you can take directions to have the plea taken. Then the matter can come for the trial.
On which fact?
On E11 is going to work. For purposes whether consolidation will be done or not.
On whether?
The necessary applications.
Okay, just prosecutor,
Yes.
with the permission of the defense, I think it's an issue that can be sorted out once and for all. So what the question you should be asking yourself is, if you want to proceed either on this file, 1171 is for this 1268. A decision has to be made on that for us to move forward. Can I give you 5 minutes? Very well. That's okay.